Okay, guys, today what we're going to be doing is we're going to be continuing our civil or tort lecture notes. When I saw you guys the other day, we wrapped up intentional torts. So today we're going to be looking at the other two types of tort cases. The first one is going to be neglect. Now, when we're talking about neglect, what this means is just a person acts in a certain way that creates a very dangerous situation, that creates unreasonable risk to others. And this can take a whole bunch of different forms, but I'm going to use some examples here that I'm going to kind of use throughout the lecture. Now, first off, there are going to be 4 elements that have to be proven in order to show that there was neglect and how to remedy this. Now, if we're kind of talking about big picture, when it comes to neglect, what it's really centered around is one person has a particular responsibility. That one person owes someone else or a group of people a level of protection from these unreasonable risks. Now, if you are in fact engaged in neglect, then you are in fact shirking those responsibilities. So the first element that has to be available is the duty. Now, what the duty is saying is basically this is your responsibility. You were put in charge of a particular situation by another, and you have a responsibility to them. Now, we're going to get more into this as we go forward, but I do just want to give you these 4 elements up front. The second thing is breach of duty. Somehow, in some form, that responsibility that you have, you shirked that responsibility. Now, again, we'll talk more going forward. The next one's going to be causation. And finally, are the damages, how to remedy the situation, how to make everyone whole again. Now, like I said, we're going to go through each of these elements one at a time. So we first need to start with the duty portion. Now, if we're talking about duty, I do want to give you an example here as far as overarching ideas. The duty is the responsibility. The defendant is owed a duty of care to the plaintiff. Now remember, the defendant is the person who's defending themselves. The plaintiff is the one who is bringing the case against them. So if we're looking at a level of responsibility, I do want to give you an example of a mechanic who's in charge of changing your brakes. If you take your car into a mechanic and you say, I'm going to hire you to change my brakes, you're trusting that person. You're saying, I'm going to pay you X amount so that you will do the job properly. A breach of that duty is when the defendant's conduct violates that responsibility, where they don't do what they were responsible for. Now, using this little example of taking your car into a mechanic to change your brakes, you're saying, I am trusting you to do this job. I'm paying you X amount, so I need a level of guarantee that it's going to be done correctly. So if that mechanic is going to put faulty brakes on your car, that's going to be a breach of his responsibility. His responsibility was to put proper brakes on your car. If he doesn't do that, then it's his fault. He's in violation. He's in breach of that responsibility, his duty. So if you can prove that the brakes that were put on were in fact faulty, then you'd have a case against this mechanic. You could sue that mechanic for negligence because he did not do what he was supposed to do. He shirked his responsibility. Now, of course, you do have to prove either one, that the brakes were faulty, or that the mechanic didn't put them on properly. Now, of course, it depends how you can prove that, but if you can prove it, then yes, you do have a case on your hands. Now, this is what's going to lead us into the third piece of what's necessary for neglect. The third part is going to be causation. Now, I'm going to kind of switch around to a different example here to explain causation because there are going to be 2 pieces to this. So first up, when we're talking about causation, what this means is you have to prove that the defendant's acts caused the harm to the plaintiff. Now, kind of going back to our other example, if you can prove that the faulty brakes eventually went out in the car and then you got into an accident because of those brakes, you do in fact have a case because you say, any other incident, if I had the correct brakes on, this would not have happened. The fact that he put bad brakes on my car made this happen. It's his fault. He caused this harm. Now, I do want to go to another example that's going to kind of bring in the 2 different pieces to this, as there are 2 different separate things that you have to take into account with causation. The first one is what's called the cause in fact, and the second is what's called the proximate cause. Now, in order to kind of explain both of these, I'm going to switch our example to if someone's driving a car and they cross over a double yellow line. What they have done is their actions made a very dangerous scenario. Now, if they cross over this double yellow line and cause an accident, then yes, their actions are what caused that accident. That's the cause in fact. Now, I do want to go ahead and kind of build upon this example and say, if someone crosses a double yellow line, gets involved in an accident, and the other car is a truck that's carrying dynamite, then you do have an issue of proximate cause. So again, for this little example, what I'm going to say is the car crosses a double yellow line, collides with a truck that's carrying dynamite. That dynamite explodes and kills someone 2 blocks away. Well, the negligence in crossing the double yellow line is the cause in fact. But the negligence that negligence was not the proximate cause of death 2 blocks away. The proximate cause is the harm caused must have been a foreseeable result. It must have been easily connectable. So if you get into an accident with a truck that's carrying dynamite, the dynamite explodes and someone dies 2 blocks away, well, you're probably not going to have a very clear case of the proximate cause of death. Crossing that double yellow line does not usually result in a death 2 blocks away. Now, using this example is kind of a stretch, but I think this paints a picture as to what the proximate cause versus cause in fact is. Now, I want to go ahead and move on to the fourth piece of negligence. For the fourth piece, you have to be able to prove damages, that this one person was harmed by another. Now, the damages can take several different forms. Some are more tangible than others. If the plaintiff can easily be restored to his or her pre-injury condition, that's the amount of money that must be given from defendant to plaintiff. Now, if we're using a car accident, you can make a fairly easy case as to, well, yes, the damages to the car must be made whole. So however much it would cost to fix the car, that's what would make the other person whole again. Now, if you have something that's straightforward, then it can be easy. But there's a lot of gray area in regards to damages, because to the extent of which money can be paid to make someone whole again can go down a bunch of different avenues. Now, going back to the little example of if it's a car accident and there's damage to the car, you can make that person whole again fairly easily. You pay for the damage to the car. But if there's a car accident and someone is injured or someone dies in that accident, then there's a whole other realm that can take place as far as making that person whole again. Yes, you would have to pay for the damage to the car, but there's also going to be issues in regards to hospital bills, lost wages, in fact, even an early death that you can say, well, had you not been in this car accident and that person died, that person was slated to make X number of dollars at their job for X number more years before they retired. If you have a wrongful death suit, then you can say, well, not only did you cause the car accident, but you caused this person to die. And because that person made X amount of money, you're responsible for bringing in that amount of money for a certain number of years. This is where things can get very complex, because you can say that, yes, you're responsible for making up that loss of income, but there's also going to be recovering for hardships, pain and suffering, emotional distress. If the person can prove that they are now, after this accident and after an injury, so scared to get back into a car that they can't go to work, that can be considered pain and suffering. That can be emotional distress. You might be liable for paying for that person who would have gone to work but is now so emotionally distraught that they can't go into work. you might be responsible for, in fact, paying for what their income would have been. Now, like I say, this can get into kind of a gray area and can take a bunch of different routes, but all of these are going to be considered the damages to make someone whole again after neglect. Now, let me tell you this. I'm going to go ahead and pause right here. We do have one small other section of the lecture that we're going to continue with, as I'm going to add to this with strict liability. So we're going to have a second lecture that goes with this.